So folks, welcome back to the Europedia world, and I am Abhinay Gupta. So today again we are continuing with the winding up of the companies, right? And the provisions for this chapter will be contained in your Companies Act 1956. Okay? So the main topic for the consideration under today's lecture would be the onerous property, right? So how many of you are already familiar with this term? Now the word onerous basically means something which is burdensome, right? Something that you would not prefer, you would not want it with you. They are not giving you any benefit, but rather they are kind of a liability on you, right? They are property in its cognate sense. Okay, property means asset, but they will not generate any value for you. Instead, they will take away something that you already have. Understanding what I mean to say, let us refer to the text, right? What does the act say about onerous property? So the onerous properties are the properties that have either ceased to be an asset or has become a liability, which means that the asset is not going to provide you any future economic benefit, but in return it is an obligation for you, right? Now let us understand the term onerous property with the example. So the first example that you can see on the screen is land of any tenure burdened with onerous covenant. So this is a very general example, right? You can interpret this statement in a lot of ways. For example, when we're talking about land of any tenure, it can be a short-term land, long-term land. You're holding it for a short period. You have taken it on lease, right? Or you have taken it on rent or something. So the land does not belong to you, but maybe you have taken it on rent, right? And you have a contract, and according to that, you are going on paying a rent, a heavy rent, right? So for example, if you have a factory of iron ore or something, and you have taken a spare land next to your factory where you are storing the rods that you're preparing and the stuff, right? You're just dumping it over there. But now since your company is not getting into operation, is not making any profit, there's no sale, no production, so that land is a waste. And if you are carrying that land continuously, you are unnecessarily bearing that rent, right? So that land is not gonna give you any benefit, but it becomes an onerous property for you. The covenants that are attached to that land are not beneficial, they are instead obligatory, right? Other is the share or stock in the company. So when does a share or stock become an onerous property? For example, there is a company XYZ Limited, right? And the shares used to trade in the market for somewhere around 2000 to 2500, and that was the time when the company was rising, it was growing, right? And you purchased the share. Well and good, you purchase a share, a very expensive share, and you find a growth. So when you purchase the share, the value of the shares, the market value of the shares were, let's say, 2200, right? For the next few months it went up to 23, 24, 2500, and then it again started declining. And declining, it has reached 800 rupees today. And still there is no scope of improvement in that company. Even that company is not performing well, right? People are planning to wind up that company as well. So that means you know that the value of these shares are not going to increase. So this is an onerous property. If you're holding it still, right, the value goes on decreasing, so it's a liability for you. There's no dividend that is to be paid, there's no inflation in the rate. So it's better to dispose of such properties which are not going to provide any benefit to you, but will only give you some obligation, right? The third example that we have, any other property which is unsaleable or is not readily saleable by the reason of its binding the possessor thereof, either to the performance of any onerous act or to the payment of any sum of money. So this means to say, if you have suppose if you have a building, right, that is a property for you, but you are not able to sell that building. Why? Because you have already taken loan on that building, and unless and until you pay off that loan, unless and until that mortgage on that building is removed, you will not be able to sell that building, right? So that would be termed as an onerous property for you. Unprofitable contracts, that you know that you have entered into a contract, right, that okay, I will supply you these units or this product for these many units per month, right? Now your cost for production has risen up like materially. Instead of, for example, if earlier you used to incur rupees 20 for the production per unit, now your cost of production per unit, now you are incurring rupees 40 and the sale price is 30, and you know that you in no sense can reduce that price, but due to that contract you are supposed to, or you are liable to make the deliveries of the certain required quantity. And when you know that, okay, via this contract, I'm not gonna make any benefit ever in future, right? So those type of contracts again turn out to be onerous property. Now, do you think why are we talking about onerous property over here? Because the company over here in this chapter is going under liquidation, right? It is going under the winding up procedures, going through the winding up procedures. So the liquidator, when he knows that yes, the company is not performing, the company's source of earnings have been depleted, the company has to make a lot of payment for its liabilities and to the creditors and stuff. So at that point of time, owning these onerous properties will not be beneficial for the liquidator. Now, for example, if the liquidation or the winding up takes 2 years or 3 years, and you carry these contracts and you carry these properties, what do? You gain nothing. Whatever you gain from the sale of the asset, you will have to utilize it for these onerous properties instead of paying off the liabilities. So, in reference to the onerous property, in this lecture today, we will understand the powers of the liquidator, because you have already understood that these properties should not be present with the company at the time of winding up. It is not beneficial, it is rather obligatory. So why will somebody or the liquidator want to carry obligations for the company? No, they will just want to dispose it off, right? So because they know that it's not going to make any profit, they don't want to incur any further losses, right? So we need to understand what are the powers given to the liquidator in case of such onerous property. So what do you think? What can the liquidator do with them? Very simple. As the liquidator is disposing of all the other assets, they can just dispose of these onerous properties as well. They can disclaim that, okay, these properties are no more ours. We are not going to satisfy any conditions any further. If it is not saleable, we don't want to sell it, but still we are not going to pay. Or if it is a mortgage, we are not going to pay anything. We need the mortgage to be cleared. If there is a contract, we will not produce anything. Whatever it is, right? Because liquidator has a lot of power in his hand, vested upon it by the court. And if there is something, if somebody does not allow, if there is a case, if there is some problem, then the court is always there to back up, right? So the liquidator would actually disclaim the onerous property. But how does it do so? So for that purpose, the disclaimer of the onerous property, the requirements of a valid disclaimer, right? The liquidator will issue a disclaimer. Let us see the requirements of the valid disclaimer. Now, first thing that you need to understand, right, is when the liquidator comes into the company for the purpose of winding up the company, right, they'll go through the accounts, right? The directors have prepared a statement, they'll give the statement to the liquidator will go through the statement and then identify what are the onerous properties that are lying with the company, right? Now, once they know that, yeah, these are the onerous property, now it is on the liquidator to decide whether or not to accept them. If they do not accept it, they will have to disclaim the property and then be freed from that. So how does it happen? They have to issue a disclaimer. What is a valid disclaimer? Let us look into this. So this is a slide on your screen, and you can see we have 5 bullet points over there in the box. So the first is that the disclaimer that the liquidator would issue will have to be signed and stamped by the liquidator. The liquidator will say that, yeah, these are the properties. They prepare a long list of all the onerous properties and just give a disclaimer that we disclaim that we disown these properties. We are not going to satisfy any further conditions of the contract, right? I am the liquidator of the company. I won't allow the company to move ahead with any of certain facts. Why? Because all the operations of the company have already come to a halt. The directors have left. I have taken away all the power. The operations of the company have been stopped. They are continuing only in the case of beneficiary winding up, but in that case, the control has moved out from the hands of the director and has shifted in the hands of the liquidator. So what happens with that is that the liquidator gets the power to disclaim the onerous property. So it issues a disclaimer, it signs the disclaimer, right? But that disclaimer would be effective only when it is provided a leave from the court. So the court says, okay, you disclaim the property, leave them, I don't have any issue with that. But because the other party to the contract, right, that party will lose something. Because if you were paying the rent on the land and now you disclaim the land, then the rent is lost by the second party. So it is not a wholesome discretion that, okay, I have done this and this will continue like this. No. the court will also see that no, it is a very harsh step taken to disclaim the property abruptly, and that will impact the other party to the contract, then in that situation the court may also insert some of the terms and conditions. They'll disown the property, but they'll have some terms and conditions that okay, maybe in future if we are revived or if something is going good, we'll take you back. If we find some position for you, we'll take you back, or we'll try to pay you off these things, that things, whatever it be, right? There are certain terms and conditions that the liquidator can enter into and dispose of these onerous properties, right? Now, what do you think? When should the liquidator give the disclaimer? Okay, you had the property and you're continuing with the property, and at the end, the last month, you give a disclaimer. What is the point? You have carried it throughout the period. You have been bearing that obligation. So for 1 month's sake, if you are trying to save the company, it's of no help. If you wanted to do something, you would have done it earlier. Got the point? So what, according to you, should be the time limit for the court, for the liquidator? That if you do not want a property, please inform us within the specified time, and if you do not inform us within the specified time, we'll consider that you have accepted it, right? So what will the liquidator do? The liquidator will try and evaluate. Once it gets the information of the property that okay, these are onerous, the liquidator will take some time and evaluate whether or not it will be beneficial to continue with this company, beneficial winding up, right? So that is a time period of 12 months from the day it comes to know about the contract. But for example, if from the day of appointment, but if there are certain contracts that were not known to the liquidator in the beginning, but came to his notice somewhere later, like maybe 1 month later, 2 months later, 3 months later, so you will construe that 12 months from the date when which the case had come in front, or case has approached the liquidator. The liquidator becomes aware of the case, right? So if there is any property that comes into the notice of the liquidator, suppose 3 months hence, then from that day the liquidator will have another 12 months period to disclaim the property, right? And this time period can also be extended by the court, right? Next point, if we see, then before the court grants a sanction to okay, go on and disclaim the onerous property, the court will have to check what are the implications of that decision, right? They may require that the notice is given to the person who are interested, the other party of the contract. They should be given a notice that okay, the company is going to liquidation, and hence we are disclaiming this property of yours. That is an onerous property for us. Although it's generating revenue for you, it is an onerous property for us, and we would not want to continue with that profit, with that contract, right? So that is one thing that you understand. That okay, if you don't want a onerous property, just give a disclaimer, sign it, stamp it, get it approved from the court, and within the next 1 year, give it out to the other company. But now one more thing, right? For example, when there was a party in the market, they came to know that okay, the company is going to be wound up, and there's a liquidator that has been appointed, and now they are not sure whether or not they will get their money, because they are not in the category of overriding preferential payment, right? So when and how do they get? So basically, the other party to the contract, when they come to know that yes, the company is going into liquidation, they would approach the liquidator and ask, sir, this is the property that we have, right? If you do not want it any further, then we can take it back, no problem with that. If you don't want this onerous property, disclaim it, we are giving you some time, right? They'll come and they'll ask the liquidator, what are you planning to do with this property? This is a property with you, right? I am the other party to the contract. You are supposed to pay me this amount per month. You're not giving me any money. What are you planning? What is in your brain? What is in your head? What are you planning to do? Right? That is what questions can be put forward. And so the liquidator will also have to send a return notice, and that will be done within 28 days. Whatever notice it sends, it will send them the revert notice within 28 days. And this period to revert back to the notice may also be extended by the central government at times. For example, it goes from 28 to 42 to 52 to 60, 70, whatever days it is, right? But if at any point of time you are not able to respond to that application within the due period, and the due period is either 28 days or such date that is increased by the members, right? So if they exceed the time period of specified by the court, then it will be deemed that the contract has been accepted and it is no more an onerous property. Even if it is, you cannot dispose it off because you have accepted the asset. So if you do not want any asset, right, then at the very first instance itself, just disregard that asset, neglect that asset, right? Otherwise in the long run you may have the problem with that asset, right? So that was all about the onerous property and the requirement of the valid disclaimer, right? Now we need to also understand what will be the effect of the disclaimer. Okay, the liquidator has given a disclaimer, then what? Will it be taken seriously? Do you have people wearing it? Will the government or the other players allow it? So once the company goes ahead to disclaim any onerous property, right, what happens is that all the rights and liabilities of the company with regards or with relation to that particular onerous property comes to an end. Getting the point? So if at any point of time the liquidator comes across an onerous property, considers it to be an onerous property and disclaims it, right? So once it has disclaimed the property ceases to be the property of the company. But the court may at times also order that the company should pay the damage for the non-performance of the contract, because the other party has been impacted very severely, right? So if you had a contract and you had said that if there is a breach in contract, you'll have to pay me some damage, then the liquidator may be liable to pay that damage. The court may direct so, right? But remember, if at any point of time the court is awarding damage to that person, then he shall be deemed to be the creditor of the company now, unsecured creditor, and accordingly he'll have to prove the amount of damage as a debt in the winding up. Got the point? So now you understand what happens with the onerous property. Onerous property is a burdensome property. We don't want it. It is not going to give us any benefit, but rather it is going to be a loss for us at any point of time, right? So we do not want that property. When we are into liquidation, the liquidator will want to depart from all such onerous properties. So what it do is, it would send out a disclaimer that okay, we do not own this property anymore, and it will give out news, and everybody will come to know. It will give out a notice to the interested party, the other party, and they'll come to know that okay, the company is not interested in this anymore, right? And this has to be done within 12 months of either joining in as a liquidator or from 12 months from the date when you have come to know about the winding up, right? And then the return notice on the application, if the other person is making an application, then you'll have to give him a return notice within 20 to 28 days, right? And what happens to the effect of the disclaimer? All the rights and liabilities of the company comes to an end, right? But if as per the contract there was because this is a breach of contract, right? So as per the contract, if the other person is entitled to some benefits, then you will have to pay him those benefits as well, and then the performance of this onerous property contract will come to an end, right? So that will be all for the topic today, right? In the next lecture we'll pick up another topic, that is the statement of affairs to be made to the official liquidator. This is all that we had to talk about the disclaiming of the onerous property, right? So see you later in the next class. Until then, please stay tuned. This is Abhinay Gupta signing off. Thank you and bye bye.